Department of Archives and History. My name is Scotty Kirkland, and I have the honor of serving as Exhibits, Publications, and Programs Coordinator here at the Archives and as your moderator for today's program. We will forego our announcements today so that we can proceed with this important event. I will say for information on the Archive's upcoming events and exhibits, I encourage you to follow us on social media and subscribe to our email updates through our newly designed website, archives.alabama.gov. Our program today focuses on the recompilation of the state's 1901 Constitution. Alabamians will vote on this measure on Tuesday, November 8th. We will put several pertinent links in the chat during the program, links to resources on the history of Alabama's constitutions, and others explaining the work of the Recompilation Committee. But none is more important than this first link that we give you now, alabamavotes.gov. Here you can check your voter registration status, polling place information, and view a sample ballot for your district. In 2020, Alabama voters approved a bill to initiate work to recompile the state's 1901 Constitution. A recompilation is not a rewrite, but rather a reorganization for clarity and ease of use. The legislation limited these efforts to 4 categories: removing racist language, deleting duplicative and repealed sections, consolidating economic development provisions, and arranging local amendments by county. This work was undertaken by the Legislative Services Agency and a bipartisan Select Advisory Committee, which included elected officials and appointees. It received a rare unanimous vote in both chambers of the State House. The Legislative Services Agency provides nonpartisan professional support to the Alabama legislature through legal advice, financial analyses, and bill drafting. Our sole guest for today's History Now is Othni Lathram, director of the LSA and a key participant in the recompilation process. By virtue of his position, Lathram also serves as the state's code commissioner, and he will tell you more about that himself in a few moments. Lathram holds a degree in economics from Auburn University and a JD from the University of Alabama. He serves on a number of professional legal organizations, including the American Law Institute and the National Conference of State Legislatures. In a moment, Mr. Lathram will tell us what the recompilation is, what it isn't, and how it will appear on our November 8th ballot. But first, a bit of historical background to the 1901 Constitution. For a longer treatment of this history, I invite you to visit wethepeoplealabama.org, the companion website for the Archives' award-winning 2019 exhibition of the state's defining documents. The roots of the current Constitution date back to the election of 1874, the year Democrats regained state control, ending Reconstruction period in Alabama. Once in power the following year, Democrats called for a convention to replace the Constitution written during Reconstruction. The resulting document instituted limited government and centralized control with the legislature in Montgomery, imposing strict limits on how counties and municipalities could spend money. During federal intervention, the delegates in 1875 did not limit the political rights the earlier Constitution had extended to Black Alabamians. They did, however, mandate separation of the races in Alabama schools. Voters ratified the new Constitution by a wide margin. A generation then passed between the 1875 and 1901 constitutions. A consequential generation, one should say, which included the rise of powerhouse industrial cities like Birmingham and Anniston, the political upheaval of the populist revolt, and external factors such as how the increasingly conservative Supreme Court viewed Reconstruction-era civil rights protections like the 14th and 15th Amendments to the U.S. Constitution. Alabama voters approved a referendum for a new convention in 1901. That summer, 155 delegates, all of them white men, drafted the state's 6th governing document. It preserved many of the core features of the 1875 Constitution, including low taxes, small government, and further centralized control by laying forth a complex system by which matters of local interest were addressed by the legislature. The 1901 Constitution also disfranchised virtually all African Americans and poor whites through a series of stringent new voting requirements, including literacy tests, proof of employment, property ownership, and an onerous cumulative poll tax. Now, the legal suppression of civil and voting rights that was ratified in the 1901 Constitution were overturned in the mid-20th century through a combination of federal legislation, judicial action, and public activism. Other efforts have thereafter focused on how the Constitution structures individual and corporate taxes and issues like home rule, both of which have contributed to the size and complexity of the document as it stands today, more than 120 years after it was written. Othni, thank you for your patience during my rather long and long-winded wind-up here. I'll give you the floor here with our first question. Alabama's Constitution has more than 970 amendments. It is 50 times longer than our federal document. How did we get here?
So, Scotty, first off, I appreciated your introduction. I talk about the Constitution a lot, and I am always grateful to have an actual historian cover the historical part so that I don't butcher it in the way that I might otherwise do so. So I'm grateful for it. I'm also grateful for the opportunity to be here today. This is obviously a very important topic. The voters on November 8th are going to vote on this, and as much information as is possible to help them inform their vote is really a good thing. And thank y'all for all your efforts at Archives and History and kind of educating the public about the roots of Alabama, good and bad, and that constitutional work in particular in 2018 was spectacular. So I'm grateful for all that. So let's dig in a little bit about how we got here, right? And you set a very good stage for that. This is the 1901 Constitution is our state's sixth constitution. It was the fifth constitution written in roughly a little over a generation's worth of time, about a 40-year window. So I tell folks pretty regularly that I think few people would be more surprised that we're still living with the 1901 Constitution than the folks who wrote it. And I say that because unlike the federal process where you had a group of individuals who gathered truly trying to craft a constitution, which I like to define when I talk to students as a contract among a people by which we agree what rights we're willing to give up and what power we're willing to give to a government in order to live as a society. And that's what the federal Constitution is. That's not what the Alabama Constitution of 1901 was. It was a super code. It governed things like how telegraph companies did business, how railroads ran their business. It reserved, as you said, really all major decisions to voters who at the time, of course, were white male landowners. And so almost from the day that it was ratified, we've had to figure out ways to work around it. So for instance, the First Amendment to the Constitution dealt with what we would think of as very core government functions. And it addressed a provision of the Constitution that prohibited the government from spending any funds, any state funds, on internal improvements. So let's talk about what an internal improvement is. An internal improvement is building roads, building courthouses, building schools, those things which most of us kind of readily agree are the core functions of government couldn't be done without going back to the voters. So the First Amendment to Alabama's Constitution, a handful of years after ratification, was to allow state government to fund the building of roads. Pretty amazing that we had to amend the Constitution to do that, but we did. And then we were kind of off and running from there, so to speak. As you laid the framework, we now have 900 through this past May's primary. We have 978 amendments. Almost 750 of those are local amendments, apply to only one county or one municipality. And let's give a little bit of context to that while we're at it. What do we think the United States would look like if we allowed each state to pass its own exceptions to our federal Constitution that applied only in the boundaries of that state? And yet in Alabama, we've done that almost 750 times with respect to our counties and our municipalities. And we've created a document that is somewhat unwieldy, somewhat unpredictable in the result, county to county on various issues, and that the voters have had to come back and address issue after issue in order to empower government to provide some function. Scotty, I like to show folks, this is my version of the Alabama Constitution. And this, by the way, is just the statewide provisions. There's an entire separate volume for those local provisions. But the number of tabs, the annotations, the cases I've got stuck in there is kind of a visual representation of kind of what is necessary for me, who lives in this day in and day out, to navigate it. So let's talk a little bit then about some of the bigger efforts over the years to kind of change the Constitution and how it functions. Of course, Albert Brewer, who became governor in the late 1960s, formed a commission, looked at the Constitution kind of at the same time that a lot of our neighboring other southern states were redrafting theirs, made a proposal. That proposal didn't go very far. In the early 70s, then Chief Justice Howell Heflin, later, of course, Senator Howell Heflin, led an effort that rewrote the entirety of the judicial article. And really, at the time, transformed Alabama's judiciary in a way that was way ahead of its times, and even to this day is kind of a national model for a unified judicial system. And that was ratified in the early 70s. In the early 80s, following some efforts by Fob James in his first term as governor, and his legal advisor, Mike Waters, has recently published a book that's pretty fascinating on that run of constitutional history. But in the early 80s, the legislature took up this kind of redrafted Constitution, not substantially different substantively, but redrafted Constitution, and it passed the legislature. And then in 1983, in a case called State v. Manley, the Alabama Supreme Court said, no, you can't go this route, that the legislature's authority over changing the Constitution is limited in two ways. They could either call a constitutional convention, or they can propose discrete, individualized amendments to change the document. And so that's kind of been the pattern we've been in for the last 40 years. There have been several efforts, and we'll talk more specifically about those a little bit later and what they mean in the recompilation. But there have been some specific efforts to do what's been known as the article by article approach, which means the legislature proposed and the people ratified kind of rewrites of whole articles of the Constitution. And there've also been, of course, continuous individual amendments throughout those years. But there was never kind of an effort to make it all fit together until 2003. And in 2003, the legislature passed an act that was then codified and gave the power to the Code Commissioner, the position I do now hold. At the time, it was held by Jerry Bassett, and gave the Code Commissioner a directive and authority to create a recompilation. That recompilation is statutorily authorized. It was never ratified. However, lawyers and people familiar with the Code of Alabama know that that's what this is. The first volume of the Alabama Code is that kind of statutorily authorized recompilation. And we've been living with that for about 20 years. However, because it was never ratified, that's not our official governing document. So it's a handy tool. It's helpful to people researching. It helps folks preparing legal briefs for the courts to know where to go look in the real Constitution, but it is not official. And that's kind of where we found ourselves in 2019 as the legislature started talking about, or kind of didn't start talking about it. It had been an effort for a number of years at kind of trying to reach agreement on how to recompile. And then in 2019, the bill that became Amendment 951 that you referenced was passed, and it was ratified in 2020.
Terrific. Thank you for that introduction. We discussed at the beginning the organization of the committee, and I know that you led the public comment phases of this work, and that of course was done during the pandemic. But we'd like you to tell us a little bit about how your office and the committee went about that mandated recompilation work. Walk us through that that public process, if you would, and tell us what's different, what's moved, and what was removed.
Perfect. So 951, you've already covered kind of the topics that it allowed for work to be done in. The mechanism was 951 specifically authorized the Director of Legislative Services, myself, to propose one time in 2022 a proposed recompilation that also did those other, three charging or three charges, so to speak. And pretty early on, we decided that process would probably work better if it was done in a very transparent method, and with some of the other stakeholders at the table and for discussions. And so we created an advisory committee. That advisory committee was chaired by Representative Marika Coleman, who was the sponsor of the underlying legislation that created Amendment 951. And then from the House of Representatives, Danny Garrett and Ben Robbins were also on it. And then three senators, Senator Arthur Orr, who was vice chair of the committee, Senator Roger Smitherman, and Senator Sam Gavan. And then four lawyers who had a pretty significant history in constitutional reform and economic development work. And those four people were Anita Archie, Greg Buttress, Stan Gregory, and Al Vance. So that 10-person committee held 5 public meetings over the summer and early fall of 2021. All of those meetings had the opportunity for the public to engage, to participate, to provide commentary. We did have public testimony at those meetings. We also had a public comment period, and we had much more written comment from the public than even the participation at the public meetings. And that committee became kind of the sounding board for myself and the staff of LSA as we worked on putting together the product that we wanted to present to the legislature. So the first decision that committee made after some discussion and conversation was to start with this statutory recompilation as the base. And that helped the process tremendously for a couple of reasons. One, of course, that work had already been done. The heavy lifting of getting through the 750 to 800 amendments that existed when it was done, those were already recompiled in a way that put the new language in, took the old language out, and gave us a baseline of work. Secondly, it's a document that at least some segment of the public was already familiar with and had a 20-year history of working with, and there hadn't been any significant complaints, any instances where we observed something that shouldn't have been taken out or something that shouldn't have been put in was. The courts were familiar with it. They were comfortable with it. Increasingly, if you look at Alabama Supreme Courts today, they refer to the Constitution by section, by any relevant amendment, and then say now appearing as the section in the recompilation. So the courts were familiar with it, and it gave us a good, solid starting point to break off on. And that statutory recompilation, really does the heavy lifting of what I think is one of the most significant things of this proposal, which is it takes our Constitution and it makes it accessible, understandable, and readable to the general public in a way that it's not currently. And let me give you a couple of examples of that. So Section 102 of our Constitution in 1901 was the provision that prohibited the state from allowing interracial marriage. That provision was, of course, struck down by the U.S. Supreme Court decades ago. And in the year 2000, the voters of Alabama voted to ratify a constitutional amendment to remove that language from our Constitution. However, if you're looking at the official Constitution, that language is still in Section 102, and you have to find your way to Amendment 667 to know that it was repealed. That's a pretty significant undertaking for any citizen, let alone one that's not trained in the law. So this recompilation just takes that language out. The voters 2 decades ago voted to remove it. This gives full effect to that desire. Secondly, we talked a little bit about the article by article approach. And over time, 6 articles of our Constitution have been rewritten. The separation of powers, provisions, the impeachment provisions, the suffrage article, the banking article, the corporations article, and the judicial article. However, each of those whole article rewrites is still simply an amendment under the current structure. So, for example, the banking article, which was rewritten and ratified in 2012, is actually Amendment 872. And so, if you pull up Amendment 872, that is the entirety of the banking article, but it's in that amendment spot. In the recompilation, the banking article comes out, the old banking article comes out, the new banking article goes in. A little bit of a head note or a footnote on this process, because this was a statutory version and not ratified, the Code Commissioner, as this was worked on, actually made a handful, a dozen to be exact, so 2 handfuls plus 2, of typographical fixes that are notated in this text. We were so conservative in trying to have complete fidelity to Amendment 951, we reverse those typographical errors in what is proposed and up for ratification. So an example of that, Amendment 907 has the word repel rather than repeal. I'm a little embarrassed that slipped through our office. It was voted on and ratified in that way. In this version, in brackets, instead of repel, it says repeal. But because 951 didn't authorize typographical errors, we're actually taking that and 11 other typographical errors back to the original language ratified by the voters. The next area, the economic development consolidation, over 100 of the amendments to this Constitution deal with economic development and the ability for local as well as state government to incentivize industry and jobs to locate in our state. A lot of that is duplicative, arguably. However, after full discussion of this 10-person committee, we decided not to change any of that. We ultimately thought there were too many bond deals out, too many agreements that were predicated on specific amendments that, even though they are later duplicated, we didn't want to upset or give any potential argument or risk to undoing any economic development deals. So we decided to, other than effectuating the placement of those amendments as part of the recompilation, to not do any additional work in dealing with that duplication. Next, of course, is the racist language provisions. And we had a full and honest debate about the history of our Constitution and what provisions were still existing in it that were racist. And that full and honest debate, as well as a whole lot of the public commentary that came in related to that topic, resulted in 3 changes that are proposed in the current Constitution that's up for ratification. The first is Section 32. Section 32 is our state equivalent to the 13th Amendment of the federal Constitution, which is the prohibition on slavery. And it prohibits slavery and involuntary servitude, but it has an exception except for the conviction of a crime. And that language appears in roughly 24 of the states of our country's Constitution. And there's been an effort kind of nationally to pull those provisions out. Alabama, as you're certainly aware, and a lot of our viewers is aware, had a history in the late 1800s, early 1900s of what was known as convict leasing, or basically leasing out prisoners to private industry, or particularly agriculture industry and mining industry, of persons who were serving time in prisons and jails. It was a form of involuntary servitude. That practice ended in Alabama in the first 2 decades of the 20th century. That practice was predominantly racially based, and that's a provision that we're now taking out of the Constitution. Now, I want to address some recent concerns about that. There are some concerns that the removal of that language affects the ability to continue the prison industry programs in the state of Alabama, or prohibits us from having prisoners participate in things like working in the kitchen and other duties around our prisons. That's not true in our estimation. There's a whole lot of law, settled law, about what prisoners can be involved in, what prisoners have to be paid, and that being involved in those programs is not a form of involuntary servitude. And in fact, the state of Colorado is about 3 years ahead of us on this particular effort. They repealed their constitutional provision dealing with involuntary servitude as a punishment for a crime 3 years ago. Almost 4 years ago now, and litigation has run its course in that state, and the courts have reached final conclusion of no, that doesn't affect in any way the criminal justice system. Prisoners working in prisons does not amount to involuntary servitude, and we're very strongly convinced that the same will be true here, even with the repeal of that language. The second racist provision that was dealt with is Section 256. 256 is our provision dealing with kind of the educational policy of the state. And there's two changes in that language. The first is we're removing the entire third paragraph. And the third paragraph is the allowance of having segregated schools within the state. No debate. I think everyone universally, quickly jumps to that provision as being, one of the strongest remnants of racist language in our current document, and that comes out. A second change, which is a little bit more nuanced, is in the first paragraph of that of that section. There's a last sentence that deals with the legislature's power to preserve peace and order in its school system. And the history of that, Scotty, if you dig into it, is that was part of Amendment 111, which was ratified in Alabama shortly after the Brown versus Board of Education decision, and it was broadly advertised, both in its passage in the legislature and at the time of ratification, as being a provision to allow the state to continue segregation for reasons that weren't related to race. Now, clearly they were related to race, but the argument was that if you were preserving peace and order, you could continue to have segregated schools, and that it was somehow not a race-based criteria. The courts obviously saw through those efforts. That was not successful, but that language remains, and the committee voted to make a proposal that took that out. And then the third and final portion of the Constitution that's being amended relative to the racist language is Section 259, which was the distribution of funds raised from poll taxes. The actual substantive poll tax provisions were removed from our Constitution, or voted on to be removed from our Constitution in the rewrite of the suffrage article in 1996. That vote was successful. Obviously, the recompilation will give full effect to that effort, and the suffrage article and all the substantive provisions of poll taxes will be out. And then this additional change of taking it out in the education article, as will happen as well. And the reason that wasn't done at the same time in 1996 was kind of that article by article approach we talked about earlier, and the desire to not somehow create an infirmity as to the rewriting of the suffrage article by also crossing into the education article and pulling that provision. So Scotty, I know that's a pretty dense segment on that information, but that's kind of how the process went and where the landing spot was that came out of it.
Well, we appreciate your detailed analysis there and explanation of what was done, and I think the example of the grammar and the decision there reflects your committee's diligence, and also, as you said, the fidelity to the legislation. I said in the beginning there were 4 provisions. I guess technically there were 5, because there followed a sentence that said, "and make no further changes." So that's a good indication of what you all did there. Before we go to the next question, just a quick follow-up, Othni. We've posted the links to the Recompilation Committee's website in the chat. If you could just tell us what our viewers might find when they go there. This is, I've heard you say before, this is a place where you can show your work, you can show the committee's work in a trust but verify sort of way. So tell us a little bit about what they'll find on that website.
Scotty, I appreciate you pointing that out. We are definitely a trust but verify state, and I appreciate that. So that website's got a whole lot of information about both what happened, what was discussed, and where we landed. So at the top of that website, there are 4 documents. Well, I think there's actually 5 documents at the top of that website, which kind of, if you only want to look at what you're actually voting on, that's where you're going to want to start. So the first document is the full text of the statewide provisions. So that's up, the language that should actually be ratified. The second is the countywide or county specific local amendments. So volume 2 of the new Constitution would be local amendments only, again, organized by county first and then subject matter second. And that's the second document that you'll see. The third document that you'll see is a disposition chart. The disposition chart on the left-hand side shows the original roughly 290 sections of the Constitution. It then lists the 977 amendments that were before the committee. Remember, 978 came just in May at the primary, so it's not on this disposition table specifically, but it lists those out. And then on the right-hand column, it shows you where those went forward in the new recompilation. This is a good place to chase a quick rabbit right there, Scotty. We had tried to avoid renumbering. So you will see a number of places where what was old was repealed, and that section is actually reserved in the new. And we did that because people are so used to the 120-year history of kind of knowing when we're talking about specific sections, what that relates to, that we thought the risk of confusion outweighed any benefit of kind of recapturing those numbers and using them for a different provision. The next document on there is a chart. I think it's entitled Chart of Textual Changes. It lays out in full glory the 15 instances where we changed text as opposed to just organization in the new document. So those 12 typos we took backwards, and the 3 provisions of racist language and what's being done in those specifically. And then the final document in that first box is the actual sample ballot language itself, so that the voters can familiarize themselves, and we're going to talk about that later, but what they're going to see on the ballot and read it ahead of time. Below that are all the materials that the committee considered, all the memos we wrote on various issues at their direction, the fantastic memo from Archives and History on the involuntary servitude provision and the convict leasing program that existed in Alabama. And those are organized by the meeting date in reverse chronological order that they were presented to the committee. So everything that the committee saw, any member of the public can now see on our website if they want to dig deeper than those final documents.
Great. Thank you. Thank you very much. It's a good time for us to invite our viewers today to put your own questions for Mr. Lathram in the chat feature. We'll take as many of those as we can in the time remaining. I will move on to another question here. As is the case, I guess, with most legislative action, there are those that feel that the recompilation effort goes too far, and others who probably feel it does not go far enough. This being a democracy, of course, our fellow Alabamians are entitled to their opinions. But I wonder, as the person charged with conducting this work, how you might address some of those criticisms that you've heard. I guess put another way, what would you want skeptical voters to know about this effort ahead of November the 8th?
So, Scotty, great question. And I'm definitely hearing from people on both ends of that spectrum, and the public's reading, various commentary, I think, on both ends of that spectrum. And I guess, I'd start with, you kind of hit the nail on the head, right? I mean, this was certainly a legislative process. It is democracy in action. That usually means there is compromise. I suspect if you talk to people who voted for this bill and this effort, for that matter, there are plenty of people who probably wish they could have gotten a little more, and plenty of people who didn't really see why we were doing it at all. And yet we landed at a spot, and I think this is significant. We landed at a spot where both the underlying legislation that proposed Amendment 951 and ultimately the recompilation itself passed both chambers of the legislature unanimously. And that's not as uncommon as it sounds. I think people think that the Alabama legislature is highly divided, and certainly there are minority of issues where they are highly divided and it's very contentious and a lot of debate. But on the vast majority of true governance type issues, they're able to work together really well and bridge the partisan divide and pass things either unanimously or in a broadly bipartisan manner. And this is one of those examples. So I guess that's the first thing that I would say, is that certainly it was the product of compromise. It was the product of the legislative process. And that's kind of how our democracy is structured. So that oftentimes you end up in a spot where maybe you wanted a little more, maybe you wanted a little bit less, but this is what you could live with. The next thing I would say is that it is extremely significant. In fact, I would say kind of critical to the continuation of democracy that people have an opportunity to know and understand the law if they want to. And I think in our current structure, that's very, very difficult with the Alabama Constitution. We've already talked about a couple of examples of things, where you have to fight through hundreds of amendments to know it's been changed. And that has an effect. It has an effect on the understandability, on the comfort level we have of, is government functioning right? And having a document that can be read front to end in a coherent and relatively understandable manner is very, very significant. So even if this did nothing other than the reorganization part, I think it would be significant. And then finally, I think language matters. I think when a middle schooler or a high schooler is first exposed to the Alabama Constitution, because they're working on something at school or they're involved in a youth government, program or one of the other many great programs around this state that expose, children to the Alabama Constitution, it matters. Even if they know segregation can't still happen, it has an effect to see in that governing document that it's still there. Even if they know that interracial marriage is no longer illegal, it has an effect to see in that document that it's prohibited in our state. And so I think words do matter. I think they do have an effect. I think purging ourselves, our governing document of these things where they are visible for those first impressions is not insignificant. I certainly understand and respect people who think there's a lot more change to be had. I guess I understand it doesn't matter because it's not operative anyway. But I think just because it's not operative doesn't mean it's not affecting people, number one. And number two, to the original point, just having the ability to read it, understand it, see it in context is something that I think citizens are entitled to. And I think make this, a significant step forward. And it's kind of the capstone, if you will, on that whole article by article approach too, right? We talked about how kind of over the past 5 decades, we've rewritten a majority of the articles in the Constitution. That's been kind of a process that, both sides of the spectrum have gotten comfortable with. And yet we haven't really taken that final step of implementing it in a way to where that's visible. And this doing that is significant.
Right. I recall you saying, or in an earlier setting, that this was sort of the next step to that article by article revision. To your first point, historians, particularly political historians, such as myself, we often have to practice law without a license, it seems, and ease of use is particularly important. But really, to the second portion, your point about language, and a constitution as a collection of our collective ideals more than a broader legislative document, which is what historians have mostly referred to the 1901 Constitution as. So I think all important changes there and good answers, I think, to the questions that we've had about the document. I have an all-important final question for you today, Othni, before we turn to our audience members. Tell us how the recompilation vote will look on our November 8th ballot.
All right. So, and I think we have a slide to throw up on this, or throw up for this. It's going to appear, you're familiar with the normal ballot style. Of course, federal offices first, statewide constitutional offices second, and then you work your way through the local candidates before you then get to the constitutional amendments. This is going to appear between that last local candidate and before Amendment 1. And the language on the screen, and again, it's also available on our website if you want to look at it closely, is the actual question on the recompilation itself. And it's a standalone section on the ballot. Scotty, while we're here, I also want to flip to this second slide. And we haven't talked about this a whole lot, but there's also a companion constitutional amendment, and it's statewide amendment number 10. And this goes hand in hand with the recompilation. And in fact, it has no effect unless both the recompilation and Amendment 10 are ratified. But if both of those events occur, Amendment 10 does two things. The first is 27 amendments are pending on the ballot. We don't want to have the Constitution of 2022 and immediately 27 amendments to go with it. So the first thing it does is it gives authorization to the Code Commissioner, my position, to place those other ratified amendments into the new document and organize them as they would have been organized if they were before the process as it had been ongoing. Not make any changes to them, not change any words, but organize them where they would belong so we don't have any amendments on day one. The second thing, and I think this is also very important to think through, we obviously have hundreds and hundreds of judicial decisions and government actions that have been taken over the last 120 years that rely on different provisions in this Constitution. And there at least exists, I think it is not a prevailing argument, but there at least exists an argument that you look at the definition of words at the time of ratification in order to know what they mean. And so all of those decisions hinge kind of upon what the meaning of words were either in 1901 or at the time that the amendment that proposed them was ratified. And so the second part of this amendment says all of those decisions remain intact, that simply reorganizing and ratifying this reorganization doesn't change the meaning of anything that is otherwise unchanged. So the vast majority of provisions in the Constitution that are simply reorganized, moved around, put in a proper place, we're not reopening for interpretation what they mean. So that's kind of a preemptive strike, if you will, to avoid unnecessary litigation and cost and expense about something that I think would reach that result anyway, but it kind of cuts it off before it ever starts.
All right, terrific. Well, thank you for that. And just a quick reminder to our viewers, you can post questions in the chat. We'll get to a few of those now, but also a reminder that alabamavotes.gov is where you can go and check your registration status, your polling place information, but also see the sample ballots for your particular precincts as well. Othni, we're going to throw up a question now from Kyle Whitmire. And I think we may have to read this in two parts, but I'll read it here from the screen if that's all right. In 2011, U.S. District Judge Linwood Smith cracked the door open for a possible court challenge to the 1901 Constitution on the basis that black belt voters had had their votes stolen and the Constitution ratified by fraud. It's a quote from that ruling. Plaintiffs did not base their claims in this case upon the illegitimacy of the 1901 ratification election, however. Indeed, they did not even allege that fact. As a consequence, this court must leave that issue for another day and another forum. Close quote from the opinion. And here's the question. By voting for this, if approved, does this provide the state constitution protection from such a challenge?
So I think the answer to that is obviously pretty complicated, and so I'm going to do my best, obviously off the cuff without having done a great deal of legal research specific to that, and then maybe we can follow it up sometime. That probably would be an hour unto itself pretty easily, right? So I'm very familiar with that litigation. That quote comes from part of the equity funding litigation over how our taxes are structured and how we fund local school systems in the state of Alabama. And the ultimate opinion in that case, by the way, was as I remember it, it was over 1,000 pages. I think it was approximately a 1,200 page court opinion, which is pretty significant and impressive in its own right. That ultimately said, perhaps we fund education poorly, perhaps we underfund education, perhaps there are issues with the funding of education, but at the end of the day, there was not a claim based on race at this point for how that was done. And that decision was ultimately affirmed by the 11th Circuit Court of Appeals. And I guess, to not to minimize Kyle's significant point, but I guess I would say two things to that. The first is that I think that if there was a so motivated plaintiff, 11 years have elapsed since that quote was written. And there were a lot of tremendous lawyers on both sides of that litigation for the near decade that it went on. A lot of them on both sides, close personal friends, really good lawyers. And so I think that if there was a claim, it is unusual to have a federal judge invite a claim in the way that quote that Kyle just referenced did.
Yeah.
And yet that I'm aware of, there was not a case filed after that kind of taking that judge up upon his invitation. And so the first thing I would say, again, without minimizing the thought or the concern or the validity of it, the fact that didn't happen despite the invitation, I think goes a long way towards answering the question, what's the viability of that, right? For lack of a better word. Secondly, I actually think in some respects that Amendment 10 covers that ground as well, right? I mean, I think the notion of Amendment 10 saying we're not, those provisions that are unchanged, we do not intend to change how they are interpreted or derived from their 1901 form, probably means that if somebody wanted to still take the court up upon that invitation, that there is a window that Amendment 10 opens that otherwise might have been foreclosed. I'm kind of out on a limb on that one again, avoiding my normal advice of not answering legal questions in the moment they are asked without researching it. I'd love to go into more depth on that later after I do a little bit more research, but I think that's my off the cuff is that, kind of those two segments. One, if that was really viable, it would be unusual that hadn't been done in the 11 years since the invitation was issued. And secondly, I think probably we're not, undermining any potential claims should it be brought, assuming ratification of both Amendment 10 and the recompilation.
Terrific. Well, thank you for that. And we're happy to revisit that question at a later point. And it sounds like you've queued up for us, Mr. Whitmire, another History Now program with Doug Smith as well. So, who's a good friend of the department. While we wait for any other questions, just walk us through just very, very briefly, Othni, the mechanics. If the voters approve these initiatives on November 8th, how soon do we see these changes enacted?
So fantastic. Good question. So first off, I want to plug, there is actually a version of the proposed Constitution. It's out in print. It's available. It was mailed to every code subscriber already at no expense to the individual subscriber. And if there's anybody out there who'd like a copy, feel free to reach out to me, or they can reach out through you to me. And we'd be glad to get them a copy while supplies last. And of course, it's available online as well. So by operation of our Constitution, and we did not override it in this amendment, there's a specific provision that says if there is a new Constitution ratified, it goes into effect January 1st following ratification. So assuming that that the Constitution is ratified, it would go into effect on January 1st. That gives us a few weeks' time, assuming Amendment 10 is also ratified, to get those other ratified amendments, see what else was ratified, get them placed into it. Hopefully get this loaded up on the website and kind of the way people are more used to seeing the code and the Constitution with that kind of click by tree, in a way that's a little easier to navigate than the current PDFs. And then also lets Westlaw and Nexus and all the other great legal publishing houses kind of catch up on that end of it as well.
Good. All right. Well, thank you for that clarification. I have really a question, perhaps to me, it sounds like a question of semantics, but it's an important one. This will be the Constitution of 2022, I gather, not a version 1901 point 2.0. Talk to me about that. What's the understanding there of updating the year to the current, and what does that mean for us?
Yeah, so I think that's a great question, Scotty, and I think my answer to that is got multiple parts. First off, certainly the core of this new Constitution gathers a lot of parts from 1901. However, I mean, even without the recompilation, let's recognize that we've amended that 978 times, right? So taking that into reference, there's I think approximately 290 provisions in the 1901 Constitution as it was ratified. So we've either added, deleted 3 times as many plus over the course of the last 20 years, right? So we really don't have the 1901 Constitution anymore, right? We have bits and pieces of it that has been changed very drastically, right? And then secondly, I think kind of achieving the tone difference, right? And again, whole lot of other things maybe some people would like to see, other things other people don't want to see, but achieving the tone difference of really removing those most offensive parts of it is such that I think it would be an unfair characterization at this point to call it some version of the 1901 document. I think that the totality of the changes make it enough different that it is worthy of a new date, so to speak, right? And that's kind of how we title these things, is by date, and I think this effort is worthy of that.
All right. Well, thank you. Yeah, and that's essentially what I've heard from some of the elected members of the committee, Representative Coleman most recently as well. So thank you for that answer. All right. Well, as we close today, I want to thank Othni Lathram, the Director of Legislative Services Agency, for joining us. And more broadly, Othni, thank you for your service to the state of Alabama. And I want to take a final moment to encourage all of you to vote on November the 8th. If you found today's program informative, please consider sharing it with your Alabama friends and family. It is available right now to share through Facebook and YouTube. This will conclude our special installment of History Now, focusing on the recompilation of Alabama's Constitution. Thank you for watching, and be well.